Hi there. Welcome back to the step-by-step guide on how to write an A-level law essay. If you haven't seen my first video, I would recommend that you do so as it is an introductory video to my channel and how my video guides work. Before we begin, please note that this video guide will be most effective for you if you already have some basic knowledge of the relevant chapters that I will be discussing. In addition to that, I will not go through every single detail of the content of the essay in the first video, as it is meant to be a quick tutorial. As this is part 1 of the video, detailed explanation and discussion of the contents of the essay will only be done in part 2 of this video guide, where I will go through with you the essay in detail. If you find this video guide useful, please like, share and subscribe to my channel, and don't forget to click on the bell button to get notifications of new videos, as I will be making video guides every week. With that said, let's get started with part 1 of video guide number 2. The question of the day reads, an alternative dispute resolution is better than a formal court resolution of a civil dispute. Discuss the advantages and disadvantages of an alternative dispute resolution and consider to what extent do you agree with the statement above. To answer an examination question, we must first take note of two things. Which chapter is the question covering, and what is the focus of the question? By first considering these two aspects of the question, we will know how to address the question appropriately. From the question, we can infer that this covers the chapter Alternative Dispute Resolution. And the focus of the question concerns the advantages and disadvantages of ADR, and to what extent do we agree with the statement. As per usual, a complete essay needs to be structured properly. Therefore, our essay should include an introduction, relevant points, and finally, a good conclusion which addresses the question. Introduction. As ADR is very much part of the civil court proceedings, it would only be proper that we start by defining what civil law, civil courts and civil disputes are. To keep it simple, we should only briefly explain that civil matters are usually between two or more private individuals, whether they be human beings or incorporated legal entities. Going into ADR, we should now introduce the fact that a formal court proceeding isn't the only way to solve civil disputes, but that people can opt for some other ways which does not involve the court. It should be noted that the sequence of introducing civil courts first before ADR is important, as a civil court procedure is the main and most important way to solve civil disputes, while ADR is an alternative method of civil dispute resolution. For the thesis statement, before we consider if ADR is better than the civil courts, we will first have to develop our answer by addressing the workings of both ADR and the civil courts, and its advantages and disadvantages as well. This would mean that we will have to discuss the detailed workings of the civil court system and its shortcomings and how it led to the origins of ADR, which was stemmed from those shortcomings. To really decide on which method is better, both the advantages and disadvantages of ADR should be discussed with equal attention given, while some comparisons with the civil court system should also be highlighted. That way, we can then critically evaluate the issue and come to an informed conclusion. Point 1. To start off, briefly explain how civil disputes and civil courts in a formal proceeding work. Here, we do not go into too much detail, but to simply discuss some of the civil court's formal procedures in litigation that is relevant to the discussion of ADR. This is where we can highlight some of the problems faced by litigants in the civil courts that it drives them to seek alternative methods of dispute resolution. Some of the problems that can be highlighted are the fact that the procedures are very formal and very public, and that it would also take quite some time before a case is actually tried by a civil court judge. That its completion is another hurdle to litigants, costing both time and money. And most importantly of all is the trouble litigants have to go through whilst not actually having any guarantee of its favorable outcome. With the problems of the civil court system highlighted and emphasized, we should now briefly mention about the WOOF reforms, with especial regards to its encouragement for ADR. I feel that it is important to mention the WOOF reforms as it is one of the driving factors for the use of ADR to supplement the civil court system and also to upgrade the system itself. Therefore, a brief introduction and explanation of the purpose behind the WOOF reform and how it relates to the increasing use of ADR should suffice. Point 2. From this point on, we will have to address the focus of the question. To do so, we will now briefly introduce the many advantages to using ADR compared to going to the courts. The many advantages of ADR can be accompanied with the discussion of the various ways in which one can solve their disputes outside of court, such as direct negotiation, mediation, or arbitration. These methods should be discussed in detail, albeit focus should be directed on the advantages of using these methods. This can be done by highlighting and emphasizing some of the most important aspects of ADR which makes it a good thing, such as the privacy and simplicity of negotiation, the flexibility and self-imposing nature of mediation and arbitration, and the general cost and time reduction of using the various ADR methods. It is important to note that in a question which asks us to critically consider the advantages and disadvantages of any concept, systems, or methods, we should deal with it exclusively first and not digress by relating to the other point. In this case, would be mixing up the advantages and disadvantages of ADR. The facts of a particular concept, principle, or method should be properly developed first before we can see how this can be contrasted with other related discussions. Point 3. To address the contrasting point, we will now briefly state that there are also many disadvantages to using ADR. Though there are various ways for which a dispute can be settled out of court, if the parties do not work together, nothing can be solved. The various ways to ADR should be mentioned here again, but the emphasis now should be on some of the disadvantages to using particular types of ADR. Cost and time settlement will also increase exponentially when disputes cannot be solved outside of court, and this will continue to balloon when a professional mediator or arbitrator is involved. This problem will arise in all forms of ADR as they all involve cost and time. Here, we can emphasize more on the commercialization of professional mediators and arbitrators to show how such services will inevitably make actual litigation in the court a more economical option compared to ADR. Other issues faced during an ADR proceeding should also be highlighted, especially when it concerns a serious point of law where it would be very unsuitable for it to be dealt with outside of court. To prove this point, we can highlight the fact that judges sitting in English courts are more suited to deal with points of laws since they are the ones with the proper jurisdiction to deal with any matter relating to the development of the law. This can be compared with the fact that though some mediators and arbitrators may have legal backgrounds, they do not have the authority to make decisions which involve the law. Point 4. This is the part where we will be addressing the second part of the question, as in the part where it asks us to consider to what extent do we agree with the statement above. To do this, we will have to briefly re-evaluate the advantages and disadvantages of using the ADR and then compare it with bringing a civil dispute to the courts. Here, I would recommend that candidates only highlight some of the most important aspects of the arguments which the candidate is most familiar with or, in their view, most critical. Next, we should give some examples of cases that is suitable for ADR and those that are more suitable for an actual court hearing. To do this, we should direct the attention on the good points of ADR and or the civil court proceeding respectively. And again, it is up to the candidate to decide on what are good points that should be critically highlighted. And with simple examples given, link these back to the statement of the question and consider if we agree with it after critically considering the advantages and disadvantages of ADR. Here is where candidates can go all out to give their own views, comments, and opinions on the matter so as to show genuine understanding on the topic of discussion. A good and critical view on any discussion is very important to secure extra marks for the whole answer. Conclusion. To conclude, we should briefly summarize what we have discussed throughout the essay. The summary should briefly highlight some of the most important points of the essay which addresses the question properly. Lastly, we should address the question by stating our stand on whether or not we agree with the statement above by highlighting some of the more important points to support our view. As the question only asks us to what extent do we agree with the statement above, it should be noted that what we conclude our essay with does not matter, as it all depends on which side of the argument we lean upon. This would mean that while we are discussing points 2, 3, and 4, it is up to us whether our arguments are leaning more towards ADR or towards the civil court proceeding. That is the end of the video guide. I hope it has helped you in your legal studies. Do check out part 2 of this video where I'll go through with you the full essay answer to this question. I will link the video in the description below. If you have any questions, comments, or any suggestions on what other topics you would like me to cover, please leave a comment on the video. And again, if you find this video guide useful, please like, share, and subscribe to my channel as I will be uploading new video guides on different topics every week. Thank you.